Morning, everyone. I'm Judge Corey Amanda Kaufman, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. Remember that today is not your trial date, and I encourage you to speak with your attorney before speaking on the record today, because everything that we say is being recorded and can be used against you at a later date. If you are represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present both here in court with me and at the main jail. For those of you at other facilities, know that these attorneys are available to you by phone. For those of you represented by private counsel, know that your attorneys come here to the courtroom with me so that they can address your case from here. If your attorney is not present in the room when I call your name, you can let me know that, and we will try to help facilitate you through that process. However, I ask you not to tell me that you have private counsel unless you or your family have retained counsel for this specific arrest. You also need to know that in the courtroom with me, I have attorneys from the state attorney's office, as well as representatives from confinement status, pretrial supervision, and the clerk of courts. All of these persons are here to help facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at first appearances if you are here for misdemeanors or municipal ordinance matters, but please understand that that is dependent on what is going on with you personally and your case. For those present for felony matters as well as violations of probation where the judge has already set a no bond hold, know that that cannot be resolved or changed here at first appearances. After today, your case will be assigned to a division judge, and going forward, all pretrial motions and any subsequent trial will be heard before the division judge. Before I get started with our regular docket, I do have a few people that the jail's requested to be called out of turn. So I'm going to start off with Stefan Weber. He's on page 6.
He's here. And Judge, he's approaching. Come on up, Mr.
Thank
Weber.
you. Good morning, Mr. Weber. Mr. Weber, you're before the court this morning on count 1, touch or strike, battery, domestic violence. Count 2, resisting an officer, obstructing without violence. Count 3, tampering in a misdemeanor proceeding. I find probable cause for these charges, and I'll hear from the parties. Mr. Romero, do you want to go while Mr. Linder takes a moment?
No problem, Judge. And speaking Mr. Weber, Judge, my understanding, he's 37 years old, been living in our community for the past 2 years. Now he's not working and gets disability. Judge, my understanding he has prior contact with the criminal justice system. My understanding, though, it was dropped, however, so I believe he has a clean record. He has very strong ties to the community, Judge. My understanding, he served in the United States Army. He served our country from 2003 to 2006. I did advise him because of the domestic situation, the court is going to impose a no contact order. He will be abiding by that order. He'll find a separate place where to reside and abide by that court order. Judge, considering he's receiving disability, he's not going to be able to afford much of a monetary bond. I'm going to be asking on count 1, the misdemeanor offense, I'm going to be asking for a $1,000 bond. And on count 3, I'm going to be requesting a $500 bond on Mr. Weber's behalf, Judge.
Stephen.
Thank you. State.
Your Honor, I'm concerned, as you can see, it's noted in the end of the report. Not only has he been arrested for domestic violence battery 4 previous times, but they're all pretty recent. Since September 5th, I would note that in Broward, he's been arrested twice for domestic violence against the same alleged victim. Once for domestic violence, domestic violence by strangulation and battery, those charges were dropped, and a misdemeanor domestic violence battery against the same alleged victim, that was dropped. Based on this recent history of violence and the allegations in this case, also noting Mr. Weber's actions once law enforcement got to the residence, I'm requesting a $5,000 bond on count 1, a $2,500 bond on count 3, no victim contact.
very concerned based on the allegations that are in the probable cause affidavit as well as the history, and I'm going to note that is a very recent history with regard to the same or similar charges involving Mr. Weber. That obviously gives me great concern as to whether he is a danger to the community or to the alleged victim in this case. Based on that, I am going to impose a $5,000 bond on count 1. I will impose a $500 bond on count 3. There will also be an order of no victim contact. Mr. Weber, I understand that you reside in the same residence as the alleged victim, but you are going to have to find someplace else to reside for the time being, as your attorney, Mr. Romero, pointed out, because no victim contact means you are not to be in the same place at the same time. There will also be no phone calls, no text messages, no social media, no third-party contact with the alleged victim. Do you understand that, sir?
Yes, sir.
Thank you. Next will be Randy Acuna on page 10.
He's approaching Judge Maine.
Thank you. Good morning, Mr. Acuna. Mr. Acuna, you're before the court this morning on count 1, driving while license suspended without knowledge. That is not for magistrate. Count 2, 3, and 4, those are each for a misdemeanor capiases. Those charges, you have a correction, I'm sorry?
Count 2 is actually a VOP.
Count 2 is a VOP misdemeanor? All right. Which has no bond? So I'm told count 2, the correction is that count 2 is a VOP misdemeanor that has a no bond hold on it. The charges for counts 2, 3, and 4 are for DUI with property damage or injury, driving with a license suspended, and failure to register vehicle. In light of that, I do see, Mr. Acuna, you have a hearing scheduled before your division judge for tomorrow morning. So those bonds, including the no bond hold on count 2, will remain in place at this time.
Good.
Thank you. Wilson Thomas on page 12.
He's approaching Judge. He's at Maine.
Good morning, Your Honor.
Good morning, Mr. Thomas. Mr. Thomas, you're before the court this morning on count 1, trespassing on an occupied structure or conveyance. Count 2 is a misdemeanor capias that involves a charge for petty theft. I find probable cause, and I'll hear from the parties.
Judge, in speaking to Mr. Thomas earlier today, he was just for me to ask the state if they have a plea offer in order to resolve both of these cases today.
One moment.
Okay.
The offer would be adjudication time served on both counts. Both charges.
Yes, he wishes to accept the state's offer, Judge.
Okay. All right, very well. Mr. Thomas, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And Mr. Thomas, do you understand everything that we've discussed here so far today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
This is psychotropic medication.
What type of medication is it?
Psychotropic.
Okay, is there anything about that medication that impacts your ability to understand what's going on today?
No, ma'am.
Okay, is there anything about it that impacts your ability to accept the plea?
No, ma'am.
Okay. Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
And Mr. Thomas, have you ever been treated for mental or emotional illness?
Yes, ma'am.
All right. Is there anything about that illness today that impacts your ability to accept this plea?
No, ma'am.
Okay. Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
And Mr. Thomas, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. And once again, your sentence as to both charges will be an adjudication time served. Good luck to you, sir. Next will be Franz Joseph on page 19.
Approaching Judge May.
Thank you. Good morning, Mr. Joseph.
Good morning.
Mr. Joseph, you are before the court this morning on count 1, grand theft auto. Count 2, possession with intent to sell, manufacture, or deliver cocaine. Count 3, aggravated fleeing with injury or damage. I find probable cause, and I'll hear from the parties.
Your Honor, Mr. Joseph's criminal history includes 2018 unlawful use of false name identity, 2015 violation of a pretrial release conditions, that being a no contact order, 2015 aggravated battery against a pregnant victim, he violated probation, 2010 battery. Your Honor, on count 3, I'm requesting a $10,000 bond. My concern is the driving pattern, which is described in the probable cause affidavit, that while fleeing from police, Mr. France crashed into 2 other vehicles. Fortunately, they were unoccupied, and I do have concerns about his future appearance in court based on the actions in this case.
Judge, under the circumstances, nothing to add from the defense.
All right. In light of that, standard bonds will remain in place on counts 1 and 2. Count 3, bond will be set at $10,000.
I'm just requesting a photo order, Judge.
That's fine, I'll sign that order. All right. Now I'm going to go into the cases that have people signed in on them, assuming that they're present in the courtroom. On page 4, Mary Visser Knopf, her private counsel is present.
Yes. Private counsel is there present.
Who's here on Miss Visser Knopf's case? Visser Knopf?
Good morning, Judge. How are you?
I'm good, thank you.
Judge, I've been speaking to Mr. Linder about this case. If we put it on a brief recall, I'm actually going to try and hunt down somebody from the Economic Crimes Unit. I believe this case is assigned to them.
Okay.
We'll stipulate, as far as probable cause purposes go, the issue at hand is bond is set at the amount of $250,000 with the Nebia requirement. There are a couple things, being that Ms. Visser has no criminal history whatsoever, and it is a large sum of money, but she's got plenty of ties to the community. She's the sole caretaker of her 3-year-old and 10-year-old daughter. We're not asking for a big reduction. We're just asking to get somewhere down in the range of $100,000 because it's an ECU case. Mr. Linder would prefer, because of the Nebia issue, that if I could speak to the Economic Crimes Unit, that we can try and get something done this morning based on that. If not, I will recall it if Your Honor would allow me.
That's all right. I can put it on a brief recall. We've got plenty of other cases to go through, and you guys will just let me know when you're ready.
Thank you so much,
All
Judge.
right.
I much appreciate the
That's all right.
accommodation.
So I'll recall Miss Visser in a little bit. I'll leave her to the side for now. Okay, good morning. This is going to be for Woodlife Florantish. We have an interpreter present, as well as, I believe, a family member or friend. Okay. That's fine.
Way at the end, like second to last case.
Okay, and for my interpreter, will you please raise your right hand? Do you swear or affirm to interpret from Creole to English and English to Creole to the best of your ability? I do. Thank you, Ms. Sainage. All right, sir, how are you this morning? Good morning.
I'm good. How about you?
I'm good, thank you. This is on page 25. Okay.
20, who's the gentleman, Judge?
It's Woodlife Florentis.
Page 25, Hector.
Okay, let me, oh, Judge, he's not here. If we could put on recall?
Okay, I have an interpreter present, so if they could get him, please let me know as soon as he's ready to go, okay?
Thank you, Judge.
All right, so Ms. St. Ange, I'll call you back in a minute. Thank you. Okay. On page 16, Charles Kokuza. His private counsel is present.
Good morning, Your Honor. Eric
morning.
Rudenberg on his behalf.
Good morning, Mr. Rudenberg.
One moment, Judge, they're gonna go get Mr. Kukuza.
Do I need to put him on recall? All right. Do we need a minute?
I think so. Yeah.
All right, I'll call him back up in a minute. Thank you, Mr. Rudenberg. Okay, let's try another one. On page 6, Demetrius Stefan Johnson has family present.
Mr. Johnson is here present at main, Judge, and we're ready to proceed.
Oh, thank you. All right. Good morning, ma'am. All right, good morning, Mr. Johnson. You're before the court this morning on count 1, touch or strike, battery, domestic violence. Count 2, resisting an officer, obstructing without violence. Count 3 is a felony probation violation, which has a no bond hold. I find probable cause for these charges. And first, ma'am, are you here to observe or to say something this morning?
I guess say something too.
Okay, so let me just tell you a couple things, all right? You're here without an attorney present to represent you. I'm gonna ask you in a moment what your relationship is to this gentleman, but understand everything that we say is being recorded and can be used against him and potentially against you in a future proceeding. Do you understand that? Okay, I'm gonna place you under oath and then we'll find out what you wanna tell us, okay? Will you please raise your right hand?
Sorry,
Do you swear or affirm to tell the truth?
the whole truth.
All right, and please state your name and spell your last name.
My name is Leah Emilie Flores, which is F like Frank, Lores like Sam.
Tell us this morning.
I just want to let you know that this is a misunderstanding and that I'm sorry and that he shouldn't be there. And that's my fault. And that I'm pregnant. And that
Sorry?
I'm all over the place. I didn't want him here like this. It's my fault that he's here because I'm an emotional wreck right now. And I just thought you should know I'm not scared of him at all. Like not even one bone in my body. I love this man. He's the father of my children. I've known him my whole life.
All right, Ms. Flores, anything else that you want to tell me?
Good morning.
All right, I'm going to hear from the attorneys now as to bond and release conditions. State.
Your Honor, I'm going to be requesting a $2,500 bond on count 1 in the order of no victim contact.
It's too much.
Well,
I'm sorry.
Ms. Flores.
Right.
while I certainly acknowledge what Ms. Flores is advising the court of, it cannot be disputed at this point that it was Ms. Flores that decided to go to the Sunrise Police Department at approximately 11:30 in the morning. They weren't called to her home. She sought them out and advised them, and you can see in full detail this officer's report of what she advised law enforcement happened. She specifically mentioned concerns that she had with respect to Mr. Johnson. Officers went to the location to try to speak to Mr. Johnson to get his say on what happened, and spoke with the victim and her mother again. He made certain statements that corroborated to an extent some of Ms. Flores's initial report. And I understand, what she's advising the court of. I also understand the dynamics of these type of situations. I would note he's on probation for a violent offense. Robbery with a firearm or deadly weapon. Your Honor, that was a 2012 case. There were also two other cases, robbery by sudden snatching, and another robbery by sudden snatching. In all three cases, he was sentenced to 56 months in state prison. In the case he's on probation for, he was sentenced to an additional 10 years probation following his prison sentence. Oh, I'm sorry, no, nothing.
Carol?
Judge, I realize he has a no bond hold on his violation of probation. On count one, it is a misdemeanor offense. I'm gonna be requesting a $500 bond. Now, I do acknowledge as far as what Mr. Lunder said, as far as, the victim going to personally seek out law enforcement, but also the victim personally here came to seek out actually speaking and addressing the court. As you heard, she said it was a misunderstanding. I don't believe she's in fear. So based on the totality, I believe what I'm requesting on a misdemeanor offense, a $500 bond is reasonable under the circumstances, Judge.
Ms. Flores, did you have something else?
Just want to say, when I went to the police station, I went with my mother. You know what I'm saying? Because when he gets mad, he needs to find a way to deal with his anger. You know what I'm saying? He's never hit me. He's never hit me, madame. But when we fight, he goes out, he walks, or unfortunately, he'll maybe break one of his things. You know what I'm saying? So, in this case, what happened was, it ended up being my car. Not me, but my car. This is why I was at the police station, because it's my mother's car. My mother is not trying to press charges on him for it because she understands where he is with his reaction of things. You know what I'm trying to say, madame? I just want to let you know, I don't fear this man. He's the father of my kids. I love him. My kids know him. I can
Flores,
show a
I'm
picture
gonna
and
stop
they'll
you.
know him.
I don't doubt that you love him, but unfortunately, I see these types of situations all the time in domestic violence situations. And the court has to go based on what's in the probable cause affidavit. I also take into consideration his prior history, and I have to make a judgment call based on that, okay?
We've been on this probation,
All right,
know.
and Ms. Flores, I want you to also understand that the no bond hold that is in
Yeah.
place on his felony violation probation is not gonna be changed here this morning.
I know, I completely know that. You know, I just
Right.
wanted to come here and let you know. You know what I mean? Madame?
I understand. All right, bond on count one is going to be set at $1,500. I understand everything that Ms. Flores is saying, but based on the circumstances, there will be an order of no victim contact.
These children.
He's not going to be speaking to them until further order of the court. So, Mr. Johnson, I understand you have the no bond hold, so you're gonna be remaining in custody. You will be seeing your division judge, I believe, tomorrow morning. But understand that in the meantime, no victim contact means no phone calls, no text messages, no third party contact, no social media. Do you understand that, sir?
Yes.
All right, thank you.
There's nothing I can do for that, madame?
No, Ms. Flores.
Okay.
Thank
What
you.
do I do now? I go?
You can go. He has a hearing tomorrow morning.
Judge, Mr. Akuza is here present.
Thank you.
Mr. Akuza? Here's your private attorney, sir.
All right. All right, hi, Mr. Rupert.
Morning, Your Honor.
Good morning, Mr. Kukuza. You are before the court this morning on count one, leaving the scene of a crash involving damage to property. Count two, driving with an expired driver's license. Count three, driving too fast for conditions that is not for magistrate. Counts 4, 5, 6, and 7 are each 4 felony probation violations. Those each have a no bond hold. If I'm probable cause, I see that you do have a hearing before your division judge tomorrow morning. In light of that, Mr. Rudenberg, is there something you want to tell me as to count one?
Not regarding count one, Your Honor. On counts 4, 5, and 6, I've just informed Mr. Linder, and I think he confirmed that there is no probation pursuant to those holds. That probation ended over a year ago. He is on, there is a probation hold for Key West pursuant to count 7 that's accurate.
Okay. So 4, 5, and 6 for the Broward holds, those are no longer in effect, is that what you're
Right,
telling me?
correct. That probation ended some time ago, and this has been an issue more than once. I don't know why the system so reflects them, but
Your Honor, frankly, I have no objection at this time to the court finding no PC and RORing him on counts 4, 5, and 6. Upon speaking to Mr. Rudenberg, I checked every individual case in Odyssey, and it does appear that Judge Bailey, at a previous violation of probation, gave him a jail sentence on each case with the special condition that probation is to terminate upon his release. In addition to that, he was, sometime last year, picked up on 94806 on all these 3 cases, and I show that within a day, and it would appear this hearing that was scheduled the next day, they were deleted from the docket, which would tend to indicate because the probation was previously terminated.
All right, then 4, 5, and 6, I'll find no PC, and those will each be an ROR. So that will just leave the other counts for him to address.
Very well.
Okay?
Thank you, Your Honor.
All right, thank you. Good luck, Mr. Kukuza.
Judge?
Yes.
Mr. Woodlife Florantis is here.
Thank you.
Judge, in speaking with him, my understanding is he said he has private counsel on this case, Mr. Scott, that he says he's been hired. He said that he just knows his first name. He believes if his brother's here in court, his brother may have his contact information, how to get a hold of his private attorney.
It's Mr. Scott Long, Judge. I left a message for him. I have not heard back yet.
Okay. Are you his brother?
Our Creole interpreter is here for this case.
Okay. You said you're his brother?
Yeah, I'm his brother.
Okay. All right. So have you spoken to the attorney?
Yeah, I spoken to him because December 2nd, they arrest him for this same thing. But yesterday night, they arrest him again. They say they put a warrant in him. I don't know why.
Okay, but let me just ask you, was the attorney retained in the prior arrest, or was the attorney retained for this arrest?
He's not here for this arrest.
I'm sorry?
He's not here for this arrest.
Okay, so, Mr. Romero, I mean, I have our Creole interpreter here. Are you able to communicate with Mr. Florantis?
A little bit, Judge, and that's why he was saying he has no idea why his attorney isn't here. That's how I was able to get that information.
Okay, all right. I'm going to, Ms. St. Ange is here as our interpreter. I'm going to use her help to communicate with Mr. Florantis. Okay, Mr. Florantis, your brother is here,
Là,
and what he is telling me
ça que li dim,
is that the attorney, Mr. Scott Long,
c'est que avocat M. Scott là,
was hired for your prior arrest,
ou te pran li pour premier arrestation,
but not for this arrest
Mais
which
c'est-
occurred last night.
mais c'est pas pour arrestation ça qui fait hier soir.
Mr. Reedy's on the phone with the attorney right now to confirm if he's been hired or not.
Your Honor, Mr. Long advises me he has not yet been officially retained on this case. He
Monsieur,
anticipates it.
Là dit que yo pas comprendre pour ça, mais la pas tant que c'est li que yo prend.
His advice to the family is to bond Mr. Florantes out,
Conseil li c'est pour payer caution et M. Florantes.
and then they will get together and work out whatever arrangements need to be
Et puis
taken
y a mettre
care of.
ensemble pour yo parler.
All right, so Mr. Florantes, in light of this information,
M. Florantes pour konya ko connaît ça qu'a passé.
do you want the public defender to represent you for this hearing?
Est-ce que vous voulez avocat public l'en représenter ou pour audience ça?
And then you can hire Mr. Long after today's hearing if you would like.
Et puis après, ou ka embaucher monsieur là après ça. Yeah.
Okay, so Mr. Romero, do you need a few minutes to talk to him, or are you ready to proceed?
I'm ready, Judge. My understanding, Mr.
Precious.
Florance's brother's going to post his monetary bond.
Il dit que frère li pral payer caution.
Okay, for the record,
pour mettre
Mr.
sous dossier.
Mr. Florentis, you are here on a charge
Monsieur
for grand theft
Florentis,
auto.
ou là pour une accusation gros vol machine.
And I find probable cause.
Nous jouons une cause probable.
Let me just ask State, do you have anything that you need to add on this?
Est-ce que vous avez des bagages pour ajouter?
Okay.
No, Judge.
Non, juge.
All right, in light of all the information that's been
Avec
provided,
toute information que vous avez,
including from Mr. Florentis' brother who's
les
present,
frères ou,
I'm going to leave the standard bond in
m'a
place,
quitté caution à Jean Lié,
which is set at
c'est
$1,000,
$1,000.
and then he'll be able to address that further with private counsel if he
On va
wishes.
parler sur ça après avec pour avocat privé.
Okay? You're welcome. All right, good luck. All right. Is there anyone, Ms. St. Ange, hold on. Is there anyone else at Maine who needs a Creole interpreter?
Bien, l'autre monde qui besoin interprète créole?
No one else here at Main, Judge.
Anyone at any of the other facilities?
Et l'autre côté?
And not as I've been told, Judge.
Okay, all right, thank you, Ms. St. Ange. Okay, I have family signed in for Jovito Santos on page 15. Oh, did she leave? Okay, never mind.
Jovita San,
Well, it seems that she left, but if you have him in the room, then I can go ahead and take him since I have his
Santos?
paperwork.
Jovita Santos? Come on. He's approaching, Judge.
Thank you. It's not Luis, just so we're clear, it's Jovito Santos.
Yes, Jovito Santos.
Okay. All right. Good morning, Mr. Santos.
Good morning, Judge.
Mr. Santos, you're before the court this morning on an immigration hold. I find probable cause for the charge. This hold, so that you understand, Mr. Santos, it has a no bond hold, which means that you'll have to go before an immigration judge to address this matter further. All right? Good luck to you, sir. All right, I do have city cases and Spanish interpreter cases, but I don't have the city attorney or the Spanish interpreter present yet, so I'm gonna go ahead and start going down our regular list, and when they come in, we'll go back to them. So next up will be Melina Boda.
She's here, present, Judge at Main, approaching. Come on up, man.
Thank you. Good morning, Ms. Boda.
Hi.
Ms. Boda, you're before the court this morning on one count for aggravated assault with a deadly weapon, domestic violence. I find probable cause, and I will hear from the parties.
Your Honor, I see no history. Your Honor, I'm going to be requesting a $1,500 bond and no victim contact.
Thank you. Mr. Romero?
I understand, and normally, under the circumstances, Judge, that would be reasonable. I was gonna be asking for about a $500 bond. I don't know if the state has an objection as far as $500.
I asked for $1,500 because I think that's reasonable considering the allegation is that she went after him with a knife. I know she claims
Judge,
self-defense.
in speaking, Ms. Boda, as you heard, she has no prior contact with the criminal justice system. She has a clean record. She's 23 years old, been here her whole entire life. My understanding, Judge, the alleged victim is her husband. They've separated since November. Ms. Bota left her husband because she was in an abusive relationship. My understanding, she went to live apart, separate from him, to stay away from him. My understanding is the gentleman did not want to leave Ms. Bota alone. Ashley came to where she was living. She's living with her mom. She's living there with her mom, with her child. She is a single mother raising her daughter. Daughter's 7 months old. She's not working right now. My understanding is the gentleman did not have permission to go to her home. My understanding is Ms. Bota wanted him to leave. He did not leave. He went inside her home. My understanding is at that time he was the primary aggressor, first initiated physical contact, and Ms. Bota tried to defend herself. Judge, I did tell her today's not her trial day. She's going to have her day in court. She applied with the public defender. She's going to be relaying that information to her attorney, hopefully contact the case filer, so hopefully this case is not filed. My understanding, the only person that's going to be able to impose her monetary bond is her mother. Her mother's a waitress, so her financial resources are limited. So based on the fact, Judge, that it happened in her premises, not in the victim's home, or the victim didn't even have permission to be there, I believe a $500 bond under the circumstances is reasonable.
And Judge, what I was about to say before, and I read everything that Mr. Romero is referring to, the thing that caught me a little off guard is that there's nothing to indicate that her ex was any threat to the child. And if she was scared for her defense, she's the one that climbed through a window to get to the room to attack him with a knife.
And Judge, that's what happened. He went inside the home without permission. Basically, then he went ahead and locked her out of the house that she resides in. The only way for her to go back into the home to make sure that their daughter is okay was by climbing through the window. So there's still a lot more than meets the eye. That's why I was asking. I believe a $500 bond is reasonable.
All right, I'm gonna set the bond at $1,000. There will be an order of no victim contact. Ms. Boda, so that you understand, no victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am. I have a question.
What's your question?
I'll ask.
My daughter,
Judge, my understanding is when she was arrested, her daughter was there. Her mom wasn't home. So my understanding is the daughter was given to the father's mother. So that would be the paternal grandmother has her 7-month-old child.
Okay.
Her 7-month-old child been living Miss Boda. So what I'm going to be asking is, can Miss Boda contact the grandmother to arrange the return of her daughter?
I see no issue with that because the grandmother is not an alleged victim in this case.
Thank you, Judge. And we're going to need a phone order so she can get the phone number of her mom because she doesn't have the mom's number memorized.
I'll sign the order.
Thank you.
Shanta Pritchard.
Ms. Pritchard, come on up, yeah? She's approaching, Judge.
Thank you. Good morning, Ms. Pritchard. You're before the court this morning on one count. This is for second-degree petty theft, first offense. I find probable cause, and I'll hear from the parties.
Judge, in speaking Ms. Pritchard, she wishes to resolve this matter. We want to see if the state had a plea offer.
Offers adjudication, time served, no return.
She wishes to accept the state's offer.
All right, Ms. Pritchard, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. You can put your hand down. Do you understand everything that we've discussed here so far today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak to your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes.
And Ms. Pritchard, what plea do you wish to enter? Guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication, time served, and please remember, there will be a no return order. That means that you are not to return to the Total Wine where this incident allegedly occurred at. Do you understand that, ma'am?
Yes.
Thank you. Good luck. And I have Mr. Plant present to address some of our municipal ordinance cases.
Good morning, Mr. Plant.
That's right, Romero.
All right. So, assuming we have these individuals in the room, I'll go down our list. Looks like we have a number of them today.
Yes, Your Honor.
Okay. First up is Brooke Georgia Cox R. She's on page 2.
I've been advised she bonded, Judge.
Okay. All right. For the record, I find probable cause. Jeffrey Mullins on page 9.
who also has a
Correct,
state
Judge.
case.
Maine?
I'm sorry?
He's also
Come on
Mr.
up, sir.
Romero's.
Okay. There's a state case on this one as well. Okay. Good morning,
Correct.
Mr.
Call.
Mullins.
Good morning, Maine.
Mr. Mullins, you're before the court this morning on 2 counts. Count 1, false identification given to law enforcement. Count 2 is a municipal ordinance violation for panhandling. I find probable cause, and Mr. Mullins, just so that you understand, Mr. Romero, who's standing next to you, is present as your counsel for count 1, and Mr. Plant is present here in the courtroom with me as your counsel on count 2. So I will hear from everyone.
Judge, it's being Mr. Mullins. He wishes to resolve this matter today.
Okay?
The offer in charge 1 would be adjudication time served.
All right. And Mr.
And the
Plant?
same, Your Honor, for count 2. So,
Adjudication time served?
yes, Your Honor, so he can resolve.
Okay. So
He wishes to accept the state's offer in reference to the state offense on count 1. I believe he also wishes to resolve count 2, the municipal ordinance, Judge.
okay, Mr. Mullins, on count 2, the offer is the same. It's an adjudication time served. Do you want to accept that?
Yes, ma'am.
Okay, all right. Will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. And Mr. Mullins, do you understand everything we've discussed so far today?
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak to your attorneys?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, guilty or no contest?
No contest, ma'am.
All right, thank you, Mr. Mullins. I accept your plea and find that it is freely and voluntarily given. Your sentence as to both of these charges will be an adjudication time served. Good luck.
Good luck.
All right, next will be Roger Plank on page 10.
North Broward.
North Broward, thank you. Good morning, Mr. Plank.
Yes, ma'am. Your Honor.
Mr. Plank, you are before the court this morning on a misdemeanor capias. This is a municipal ordinance violation for lodging on city-owned property. I
did community service on this charge. That's why I don't understand. I did 16 hours community service, which I accepted a plea bargain 6 months ago, or 5 months ago, and I had 6 months to complete it, and I did it. And I turned it in the Hollywood office down there on my Park Road, whatever, 55th, whatever avenue that is. I'm sorry.
That's all right. Let me just take a look, okay? Let me just take a look at what's going on.
Sure, you'll get credit for that. It will be a time served. You can finish your case.
Yeah, but I had no right to be arrested for this then.
Well,
That's
let me,
not
all right,
fair.
hold on, Mr. Plank. Mr. Plank, hang on just a second, please, okay? Mr. Linder, since you have your computer open, could you please, just check this case for me?
Certainly. Same as resolved. This case was actually assigned to you, Judge. It does not look like it was resolved.
See, from the system what the arrest date was on this?
Yes. Mr. Plank resolved other cases. For instance, Mr. Plank, are you talking about the case you resolved a couple weeks ago?
Yeah, but I also
Different-
have 16 hours more to do, but they gave me
Sir,
6
sir,
months
sir,
to do.
sir. Different case. He resolved a case before Judge Powell. Same charge, January 10th.
Okay, all right, so,
Okay.
okay, so,
Yes,
hold on. You're getting ahead of
okay.
me. All right, Mr.
But
Plank, hang on.
I know what he's talking about. I did go to court on this one, and the clerk lady signed the back of the paper that no, I was not on the computer there in the Hollywood office.
Okay, so
And the
sometimes,
Hollywood
all
court.
right, hold on, please,
Just wait,
hold on.
sir, wait.
Sometimes that happens. What happens is sometimes you get an NTA, and when you show up in court for your court date, The city hasn't filed the charges yet, which means that you'll get a new court date. I've seen it happen all the time, and since this is my old division, and I'm probably the one that issued this capias, I understand what probably happened here. So this was from a November court date that this capias was issued.
November 10th.
So,
I remember it perfect.
okay, so what they're telling me is we checked the system. It looks like you resolved some other cases, but not this one. Your attorney, Mr. Plant here, is telling me that if you want to resolve this case today, then the offer would just be an adjudication time served. Is that what you want to do?
Yes, ma'am.
Okay.
Sure.
Okay, all right. So, Mr. Plank, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. You can put your hand down. And do you understand everything we've discussed so far today?
Yes.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak to your attorney?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Okay, and do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes.
And Mr. Plank, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given, so your sentence on this case will be an adjudication time served. Good luck, Mr. Plank.
Thank you.
All right. Next will be Thomas Duncan on page 11. Thank you. Thank you. Good morning, Mr. Duncan.
Good morning.
Mr. Duncan, you're before the court this morning on a municipal ordinance violation for soliciting. I find probable cause. I do have your attorney, Mr. Plant, present here in the courtroom with me. And Mr. Plant, what are we doing with Mr.
Judge,
Duncan's
he can
case?
resolve his case, it would be time served.
Adjudication time
Adjudication.
served? All right, so Mr. Duncan, if you want to resolve the case today, the city's offers an adjudication time served.
Yes, ma'am.
Do you want to accept that offer?
Yes, ma'am.
Okay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. And Mr. Duncan, do you understand everything we've discussed so far today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak to your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
And Mr. Duncan, what plea do you wish to enter, guilty or no contest?
No contest.
Thank you. I accept your plea and find that it is freely and voluntarily given. So, Mr. Duncan, your sentence will be an adjudication time served. Good luck to you, sir.
Good luck, sir.
All right, next will be Mark Armstrong. He's on page 11. Thank you. Okay, what's the correction? Yes? Okay. Morning, Mr. Armstrong. Mr. Armstrong, you are before the court this morning on 3 misdemeanor capiases. On counts 1 and 2, those are each charges for pedestrian obstructing traffic with no permit. The third charge is for trespassing. I find probable cause, and I do have Mr. Romero, who's standing next to you, is acting as your counsel on counts 1 and 2, and Mr. Plant, who's here with me, is acting as your counsel on count 3, since that's a municipal ordinance violation, and I will hear from the parties now.
Judge, and Speaker Armstrong earlier today, in reference to the state offenses, Judge,
Yes.
we're just requesting a SAP order.
Okay. All right.
Sorry, his offer for the city case would be adjudication, time served, or he doesn't have to accept it.
Okay.
He's gonna do SAP anyway.
So, Mr. Armstrong, based on your request, I will sign that SAP order that was requested, okay? So I'm gonna leave the bonds on counts 1 and 2 in place if that's what you wish for me to do. And on count 3, which is the municipal ordinance case, if you want to resolve it, then the city's offer will be an adjudication time served, but you certainly don't have to if your intention is to complete the SAP program. So you tell me what you would like to do.
I'd like to complete the SAP program.
Okay.
I don't know.
That's fine.
Okay, so in light of that, I'm gonna leave the bonds in place and I will sign the order for SAP, okay? All right,
Thank you, Judge.
thank you. Next will be Enrique Vargas Torres on page 14.
Judge, I've been advised he's a medical loan.
Yes,
Medical
he's
loan?
done.
Okay,
That's it,
All
Judge.
right.
Have a good day.
thank you very much. I'll sign these orders. Still waiting on interpreters. I'm gonna go back and continue down our regular list. Next will be Justice Bryant.
I've been advised she bonded, Judge.
All right, thank you. For the record, I find probable cause. Elizabeth Pereira.
I believe North Broward. She's a medical research on.
Okay, thank you.
Good morning.
Good morning. Lisa Brucker.
North Broward.
Thank you. Good morning, Ms. Brucker.
Good morning.
Ms. Brucker, you're before the court this morning on 2 charges. Count 1 is for grand theft auto. Count 2, driving while license suspended, third or subsequent offense. I find probable cause for these charges, and I will hear from the parties.
Judge, I'm gonna be asking for a phone order.
Okay, I will sign that. Anything from the state? Okay, in light of that, I will sign the phone order, and I'll leave the standard bonds in place as is. Okay, thank you, Ms. Brucker.
That's all?
That's gonna be it for this morning. Okay?
Okay.
Thank you. Next will be Jonda Nottingham.
No problem.
Thank you. Good morning, Ms. Nottingham.
Morning.
Ms. Nottingham, you're before the court this morning on 1 count for grand theft auto. I find probable cause, and I'll hear from the parties.
She has 2 no bond holds on county charges 1 and 2. I've just asked that this bond be left in place.
Yeah, I would join in that request, Judge.
Okay, all right, then in light of that, I will leave the bond in place at $5,000 on this charge, okay? Thank you, Ms. Nottingham.
When did this take place?
Let's see, this is regarding an alleged auto theft that occurred on October 16th, 2019.
I was in West Palm.
Okay, well, Ms. Nottingham, based on the allegations that are included in the probable cause affidavit, I am gonna find probable cause at this time, and I'm gonna leave the bond in place. You can speak with your attorneys about the matter further, okay?
Okay.
Thank you. Jesse Kent.
Your Honor, if I could be heard before the court makes a probable cause determination, please?
Yes.
You're present, Judge, and me.
Thank you. Good morning, Mr. Kent.
Good morning.
Mr. Kent, you are before the court this morning on count 1, aggravated battery on an officer, firefighter, or EMT. Count 2, battery causing bodily harm, domestic violence. Count 3, resisting an officer, obstructing with violence. The state has requested to be heard, so I will
Thank you,
hear
Your
from
Honor.
the state.
Could you check to see if there's anything outside of Broward? Your Honor, I spoke to Officer Holes this morning, who authored the probable cause affidavit.
Yes.
The state is going to be requesting that the court find probable cause for battery on a law enforcement officer on count 1. No,
edits, Dave?
I'm just checking to see if he has priors. I know he doesn't have anything in Broward, but.
All right.
Well-
Based on that request, I do find probable cause for battery on an officer. I'm just going to cross out the word aggravated on the finding sheet.
Thank you. Your Honor, I'm being advised he has no history. That being said, I am concerned about these allegations. While it is not an aggravated battery on a law enforcement officer, I am concerned that he allegedly bit an officer's finger while attempting to arrest Mr. Kent. The officer had to go to the hospital to receive treatment. I was advised by Officer Holes, for bond purposes, that the officer did receive a laceration as a result of Mr. Kent biting him. Additionally, I am concerned on the allegations of the domestic violence in this matter. I'm going to be requesting a $2,500 bond on the battery on the law enforcement officer, a $1,500 bond on the domestic violence battery, and a $500 bond on the resisting with violence, and order no victim contact.
All right, Mr. Romero?
Judge, if I heard correctly, I believe the state requested $2,500 on one, $1,500 bond on two, and $500 on three. Is that correct?
That's correct, and no victim contact.
Under the circumstances, Judge, that's reasonable. We're just going to be requesting a photo order so we can photograph the injuries of Mr. Kent.
All right, I will sign the photo order. The bonds will be placed as requested, $2,500 on count one, $1,500 on count two, $500 on count three. Additionally, based on the probable cause affidavit, it does appear that Mr. Kent resides with one of the alleged victims in this case. Mr. Romero, I'm sure you've discussed this with him, but Mr. Kent, so that you understand, if you do reside with this alleged victim, that means you're going to have to find someplace else to stay for the time being, because no victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, I do.
All right, thank you. Okay, at this time, I'm going to recall Mary Visser Noth. Mr. Bloom is present back in the courtroom.
She's approaching, Judge.
Thank you. And I
Mr.
just want to,
Private
let me
Attorney
just read her
Whittemore.
charges for the record.
That's correct, Judge. And again, thank you very much for the accommodation. I found Miss Lubin from the state. She's the assigned ASA on the case. Me and Miss Lubin have gone ahead and spoken about the case. What we're going to do at this time is, because there's a nebia requirement stamped on the case, we're going to go ahead and leave everything set as it is now, but we're going to provide proof later today, hopefully, about the third party posting the collateral and whatnot. And Ms. Lubin will be open to doing a reduction of the bond at that time once when she's satisfied that the collateral does not come from Ms. Visser-Nouth and that it's free and clear of any criminal activity. Just the only thing else we're asking is that we ask the clerk's office to expedite the issuing of a case number due to the fact that in the bond order signed by Judge Weeks, that the collateral order needs to be signed off on by whoever the assigned judge is. And because it's an arrest warrant, we don't have an assigned judge yet.
Okay.
And so that way, she's got a 10-year-old and 3-year-old at home, and we're just trying to get her out and get her home as quickly as possible. The kids are in the care of another family member at this time,
Okay.
but we don't know how long that's going to last for.
Okay, all right. So at this time, I'm going to find probable cause for the alleged charges, even though probable cause was already obviously found by Judge Weeks when she signed the warrant. I will leave the bonds in place as they were set, And do you need an order from me regarding the case number for the clerk's office? Is that something that's necessary?
Asking that they expedite issuing a case number would suffice. We usually have them prepared a written form.
Necessary, I will give the verbal order for the clerk's office to expedite the setting of a case number on this case based on the information that's been provided, okay?
Thank you very much,
All
Your
right,
Honor.
thank you, thank you. Yes,
Yeah,
that's correct.
I am aware of that, although Ms. Lubin and me have spoken about it, that at the time when we provided the collateral, that Ms. Lubin would be open to addressing the conditions of pretrial at that time. So when we submit the collateral package and the agreed order, that we may end up submitting an agreed order as well to reduce the pretrial levels. I've made Ms. Lubin aware. My client has no prior. She's never been arrested, never been accused of anything. She's been a citizen of Broward for a while. She's got 2 young children who are both here that she's the primary custody taker for. So I think that will get addressed at the time of when we submit the collateral. Is that a fair statement?
All right, so for right now, all the special conditions as to bond and release will remain in place, which I wrote on the finding sheet, and then they can address that with the division judge. Thank you very much. Okay, so I'm going back to our regular list now. Alejandro Valdez Escobar.
Your President Jermaine.
Thank you. Good morning, Mr. Valdez Escobar.
Good morning, Judge.
You're before the court this morning on count 1, touch or strike, battery, domestic violence. Count 2, false imprisonment of an adult. Count 3, tampering in a 3rd-degree felony proceeding. I find probable cause, and I will hear from the parties.
Judge, my understanding, speaking to Mr. Valdez, this is the first time, he has no prior as far as domestic convictions or anything like that. I believe he may have had a cannabis maybe 4 or 5 years ago out of New Jersey. But my point is he has limited contact with the criminal justice system. He's 23 years old, been living here in South Florida now for almost 4 years. He works for a company called BX Fitness. Judge, he's been employed there for about 2 years. My understanding, I did advise him that the court's going to order no contact with the alleged victim. He will be abiding by that. He has family that live here in Broward County. Specifically, he's going to be residing with his godfather. My understanding is his godfather's the person that's going to help post his monetary bond. He works in construction, so his financial resources are limited. So on count 1, on the misdemeanor offense, I'm going to be requesting a $1,000 bond. On count 2, I'm going to be requesting a $2,000 bond. And on count 3, I'm requesting a $1,000 bond. So the defense is requesting a total $4,000 bond on behalf of Mr. Valdez.
Your Honor, it is correct. The only prior I see is a prior marijuana charge out of New Jersey. However, upon reading the report, I believe this is one of those cases where based on the strength of the evidence, the level of violence alleged just simply outweighs his lack of priors. Noting the violence alleged that he committed against this victim, that she felt it necessary to run from the apartment screaming for help from her neighbors. And based on the allegation that when Mr. Valdez Escobar caught her, he dragged her by her hair with both hands back into the apartment. And this is corroborated by a neighbor. Noting that when the officer got to the apartment, he found the victim curled on her bed underneath a blanket crying and quietly whispering, "I'm scared, help me," documenting the injuries that she suffered throughout her body and her face. And I understand, Your Honor, that it may be mentioned that she denied prosecution, provided a sworn statement indicating she does not want to speak about the incident on recording. But I think it has to be noted that the officer admitted in his observations that it appeared she was afraid to speak about the incident. Your Honor, based on the level of violence and my concerns, I also note that when asked about the incident, Mr. Valdez Escobar claims she did this to herself. The officer also noticed a small cut and redness on both of his knuckles consistent with her allegations. And I would note the injuries that were described that Mr. Valdez Escobar claims she did to herself. I'm requesting a $7,500 bond on count 1 and count 2, $2,500 bond on count 3, no victim contact. Should he post bond, pretrial release with a GPS monitor?
I understand that Mr. Valdez has limited history as presented this morning, but the allegations that are involved in this probable cause affidavit, which apparently are supported by the observations of an independent witness, being one of the neighbors who I believe is the person who actually called 911, I'm very concerned on the allegations in this case. Based on that, I'm going to impose a $7,500 bond on count 1. Bond on count 2 will be set at $3,000. Bond on count 3 will be set at $1,000. If Mr. Valdez does post his monetary bond, he will be placed on pretrial release with a level 2 GPS monitor. There will also be an order of no victim contact that includes a 500-foot stay-away order from the alleged victim in this case. I understand that the probable cause affidavit includes her statements to law enforcement that she didn't wish to provide a sworn statement, but that is of no concern to this court when it comes to circumstances like this in these types of situations. So, Mr. Valdez, so that you understand, no victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
Thank you. Mark Forcand.
That's a medical research.
Medical.
Okay, thank you. John Lewis.
I believe he was removed by confinement, Judge.
Okay, all right, thank you. Hector Aguero.
No problem. Medical research on.
Oh, thank you. James McFadden.
Mr. McFadden, come on up, please. He's approaching Judge. He's here at me.
Thank you. Good morning, Mr. McFadden. You're before the court this morning on a misdemeanor capias. This relates to a charge for petty theft. I find probable cause. Do the parties wish to be heard?
Mr. McFadden, he wishes to resolve this matter. We want to see if the state had a plea offer for him.
Stay.
For his adjudication court cost and no return to
Wishes to accept the state's offer, Judge. Yes.
no return to the Home Depot on 4th Avenue in Fort Lauderdale.
All right. Mr. McFadden, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. And do you understand everything that's been discussed here today?
Yes, ma'am.
Okay. Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, I'm not.
Do you need any more time to speak to your attorney?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes.
All right, and what plea do you wish to enter, sir? Guilty or no contest?
No content.
Thank you. I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication. You said adjudication court costs? State? All right. There'll be an adjudication court cost. And there will be a no return to the Home Depot as discussed. Do you understand that?
Yes, ma'am.
All right. Thank you. Rashawn Withers.
Here.
Good morning.
Good morning,
Good morning.
Mr. Withers. Mr. Withers, you're before the court this morning on one count. This is second-degree petty theft, second offense. I find probable cause, and I will hear from the parties.
Judge, it's me, Mr. Withers. Earlier, he wishes to resolve this matter today.
Adjudication, court cost, time served, no return to total wine and more.
He wishes to accept the state's offer, Judge.
Okay. All right. Thank you. Mr. Withers, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. And Mr. Withers, do you understand everything we've discussed so far?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
Not at all.
Do you need more time to speak to your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
And Mr. Withers, what plea do you wish to enter? Guilty or no contest?
No content.
All right, I accept your plea and find that it is freely and voluntarily given. Mr. Withers, your sentence will be an adjudication, time served, and as discussed, there will be a no return to the total wine that's at issue in this incident. Do you understand that?
Yes, ma'am.
All right, thank you.
Good luck, sir.
Garvin Foster.
Please approach the judge here at Maine. Come on up, sir.
Good morning, Mr. Foster. You're before the court. You're before the court on one count. This is for second-degree petty theft, second offense. I find probable cause, and I'll hear from the parties.
Judge, it's me, Mr. Foster. He wishes to resolve this matter. We wanted to see if the state has a plea offer for him.
Your Honor, if Mr. Foster wishes to resolve the case, the offer from the state is adjudication 5 days county jail. He was arrested by my count, 3 times in December for either trespassing at this exact location or in the immediate vicinity.
Judge, he wishes to accept the state's offer.
Okay. All right, Mr. Foster, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, Your Honor.
Thank you. You can put your hand down. And Mr. Foster, do you understand everything we've discussed here today?
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No, Your Honor.
Are you under the influence of drugs or alcohol?
No, Your Honor.
Do you need any more time to speak with your attorney?
No, Your Honor.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea?
Yes, Your Honor.
Have you ever been treated for mental or emotional illness?
No, Your Honor.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, Your Honor.
And what plea do you wish to enter? Guilty or no contest?
No Contest.
All right, I accept your plea and find that it is freely and voluntarily given. And Mr. Foster, as discussed, your sentence will be an adjudication, 5 days in the Broward County Jail, credit for any time served. Good luck to you. Antonio Sims.
He's here at Main, Judge, approaching.
Yes, Your Honor.
All right, good morning, Mr. Sims.
Good morning.
Mr. Sims, you're before the court this morning on one charge. This is for trespassing of an occupied structure or conveyance. I find probable cause, and I will hear from the parties.
Judge, Mr. Sims wishes to resolve this matter today.
State. Okay.
Offered be adjudication, time served, no return.
Is that no return to Beach Place in general or to a specific store?
Your Honor, I'm asking that it be Beach Place because it would appear that the trespass warning's been issued for the entire location.
Judge, he wishes to accept the state's offer, but my understanding is he wants to go back one time. My understanding is that he works for DoorDash, I believe. He left his phone at a store, it's a cigar store, so he wants to go back one time in order to retrieve his property.
See, here's the thing. And he needs to understand, even if Your Honor allows it, there's still a trespass order. So he runs the risk if he goes back.
Judge, I did advise that Mr. Sims, in abundance caution, what I advise him to do is contact local law enforcement so that he can make an arrangement with law enforcement so he can be accompanied, so he doesn't risk that in order to retrieve his property, and he's gonna go there with law enforcement.
If he wants to do it, then that's fine. Based on circumstances, it may be wise for him to have somebody else go retrieve the phone for him instead, based on the circumstances. It does appear that part of the information provided in the probable cause affidavit was that he was, and I'm just going to read it because, Mr. Romero, I know you haven't seen the probable cause affidavit. It says officers were advised by security that the male was going in and out of the businesses, harassing customers and claiming to look for a phone. Security advised defendant was asked to leave by multiple business owners. So I think based on the circumstances, if there is a phone that was left behind, it may be wise for him just to have somebody else go and get it for him.
Yes, Judge.
Okay, all right. So Mr. Sims, if you want to accept the offer, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. You can put your hand down. And Mr. Sims, do you understand everything that we've discussed here today?
Yes, I do.
All right. Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea?
Yes, I do.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, I understand.
Okay, and what plea do you wish to enter? Guilty or no contest?
No contest.
Thank you, Mr. Sims. I accept your plea and find that it's freely and voluntarily given. So once again, your sentence will be an adjudication time served, and there will be a no return order, and that order applies to Olive Beach Place for the record. Do you understand that, sir?
Yes, I do, Your Honor.
All right, thank you very much. Good luck. Ruben Para.
Judge, he's here present. He advises that he hired private counsel, Mr. Hugo Apayanis. I don't know if my colleague spoke to Mr. Apayanis.
I did leave a message for him, Judge. I have not heard back from him.
Okay, so, it will be up to Mr. Parra, since we haven't heard back from him, as to whether he wants you to represent him for this hearing, or if he wants it to be reset to see if somebody can get in contact with the attorney.
Judge, my understanding is, I believe, he's just simply gonna post bond. I believe afterwards, then he'll follow up with Mr. Apayanis.
Okay, all right. So then, Mr. Parra, just for the record, you were before the court this morning on one charge. This is for DUI, alcohol or drugs, second offense. I find probable cause. The bond that's in place at this time is $1,000. So let me just ask State, is there any additional information?
No, Your Honor.
Okay, all right. Then, Mr. Parra, I'm gonna leave the $1,000 bond in place, okay?
Thank you.
All right, good luck.
Mr. West
Markeith West,
is approaching, Judge.
thank you. Good morning, Mr. West.
Good morning, ma'am.
Mr. West, you're before the court this morning on 2 traffic capiases. These both involve charges for operating without a valid license. I find probable cause, and I will hear from the parties.
First, Judge, Mr. West wanted to see if his bond's been posted.
Let me just check with confinement. Bond has not been posted yet.
Judge, Mr. West also he wanted to resolve these matters today.
Offer be adjudication, time served, court cost on both cases.
He wishes to accept the state's offer, Judge.
All right. Mr. West, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. And Mr. West, do you understand everything we've discussed so far today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea?
Yes, ma'am, I understand.
Okay, and have you ever been treated for mental or emotional illness?
No, ma'am.
All right, and do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, guilty or no contest?
No contest.
All right, Mr. West, I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication, time served. Good luck. Shaquem Paul.
He's approaching, Judge, here at Maine. Come on up, Mr. Paul.
Good morning, Mr. Paul.
Good morning.
Mr. Paul, you're before the court this morning on count 1, attaching a registration or license plate not assigned to a vehicle. Count 2, operating without a valid driver's license. Count 3, failing to wear a safety belt. That is not for magistrate. I find probable cause, and I'll hear from the parties.
Judge, I'm going to be requesting a straight ROR on Mr. Paul's behalf. My understanding, he has a clean record. He's 18 years old, been here his whole life. He's going to school. He's trying to catch up on his credits with his goal to hopefully graduate July of 2020 of this year. He lives locally with his grandmother. This isn't violent, Judge. That's why I'm asking for a straight ROR on his behalf.
State. All right. I will grant the request, and I will ROR him on count 1. Mr. Paul, so that you understand, though you're going to be released today based on the ROR, that doesn't mean that this is the end of the case. That means it will be your responsibility to follow up with your attorneys and the clerk's office to monitor any future court dates that you have to be present for. Do you understand that?
I understand.
Okay. All right, good luck, man.
That's what the judge just told you, okay? Good luck, sir.
Stephen Robinson.
Oh, he's here. Come on up, Mr. Robinson.
morning, Mr. Robinson.
Morning.
Mr. Robinson, you're before the court this morning on 2 charges. Count 1 is for resisting an officer obstructing without violence. Count 2, trespassing of an unoccupied structure or conveyance. I find probable cause, and I will hear from the parties.
Judge, just being Mr. Robinson, he wishes to resolve this matter today.
Okay. There will also be a no return order.
What was the state's offer?
It would be a withholding court cost, plus I would impose a no return order to the shopping center.
Let me talk. Judge, he wishes to accept the state's offer.
They're waiting on an interpreter. Yeah. Yeah. Mr. Romero, by the way, I don't know if you heard what I was just saying. There's a couple cases it looks like we skipped over, but that's because they're waiting on an interpreter.
I thought so.
Okay. All right. Okay. I'm sorry. Did you say Mr. Robinson wishes to accept the offer?
Correct.
Okay. All right. So, Mr. Robinson, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. And Mr. Robinson, do you understand everything we've discussed here today?
Yes, ma'am.
Okay. Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
Oh, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, sir? Guilty or no contest?
No contest.
Thank you, Mr. Robinson. I accept your plea and find that it is freely and voluntarily given. Your sentence as to both charges will be a withhold of adjudication plus court costs. There will also be a no return order to the shopping center where this arrest occurred at. Do you understand that, sir?
Yes, ma'am.
All right. Thank you. Good luck to you. Ernesto Rodriguez.
Conti?
Thank you.
Your Honor, he needs a Spanish interpreter.
Okay. All right. I'll put him in my pile. Thank you. All right. So next will be Victor Ruiz Rivera.
He's a medical research, Your Honor.
All right. Thank you. Kevin Taylor.
Judge, he's here present. He informed us that he's going to be retaining private counsel, Judge.
Okay, so Mr. Taylor, do you understand that you are entitled to have an attorney represent you for this hearing this morning?
Yes.
And are you declining the services of the public defender at this time?
Yes.
Okay. All right, so for the record, Mr. Taylor, you are before the court on 4 charges. Count 1 is for carrying a concealed firearm. Count 2, possession of cannabis over 20 grams. Counts 3 and 4 are each felony probation violations. Those each have a no bond hold on them. I find probable cause. And what did you want to tell me, Mr. Taylor? What was that?
I would like the evidence be deemed admissible due to unlawful search and seizure.
Okay, well, Mr. Taylor, that's not going to be an issue that I can address here in first appearances. Here, we only address bonds and release conditions. And so that you know, you do have a hearing before your division judge tomorrow morning on the 2 probation violation issues. So in light of that, I'm going to leave the standard bonds in place on counts 1 and 2, okay?
Okay.
I'm sorry, you have a correction on count 4? What's the case number supposed to be? Yes? Yes? Okay, all right, I put the correct case number on there. All right, thank you. Good luck, Mr. Taylor. You'll see your division judge tomorrow morning.
Thank you.
Thank you.
Have a good one.
You too. Oswald Lugardo.
Judge, he's here present. He declined. He has private counsel, Mr. Mickey Rowe.
Good morning, Judge.
Good morning, Mr. Lugardo. Have you already retained Mr. Roque
Oh, yes.
For this specific arrest?
Yes.
Okay, well, he's not present here in the courtroom with me. Let me just ask Mr. Reedy, have you heard anything from him?
I've left a couple of messages for him, Judge, but I haven't heard back yet.
Okay, all right. So, Mr. Legardo, do you want me to go ahead and address your bond without him being here, or do you want me to have you reset?
I would also like to deem the evidence admissible due to an unlawful search and seizure as well.
Okay, well, as I told your
Of
friend, I can't address that here. So let me just tell you.
I just want to state it for the record.
That's all right. So, Mr. Legardo, let me just tell you, for the record, okay? I have you here on count 1 is for carrying a concealed firearm. Count 2, possession of alprazolam.
Excuse me, Judge.
Yes.
I can't really hear. Can you say that again?
Okay, yes. Count 1 is carrying a concealed firearm. Count 2, possession of alprazolam. Count 3, possession of cannabis over 20 grams. Count 4 is a tinting violation that is not for magistrate. And counts 5, 6, and 7 are each felony probation violations. And those 3 counts each have a no bond hold. All right? I find probable cause for the charges. And Mr. Legardo, I see that you do have a hearing before your division judge tomorrow morning. So I would assume that your attorney will be present with you for that matter. So in light of that, I'm going to leave the standard bonds in place on counts 1, 2, and 3. And you'll see the division judge tomorrow morning, okay? Yes. What do you want to tell me?
Is the state offering anything?
Well, they can't resolve any of that right now since you have the pending VOPs, okay? All right. Good luck to you, sir. You'll see the division judge tomorrow morning.
All right, thank you, Judge.
You're welcome. Ladarius Mitchell.
North Broward.
Thank you. Good morning, Mr. Mitchell.
Good morning, ma'am.
Mr. Mitchell, you're before the court this morning on 2 charges. Count 1, burglary of an unoccupied conveyance unarmed. Count 2, possession of weapon or ammunition by a convicted felon. I find probable cause for these charges, and I will hear from the parties.
What parties, ma'am?
I'm sorry, Mr. Mitchell, your attorney, Mr. Reedy from the Public Defender's Office, is present here in the courtroom with me. So I'm going to hear from him and the state attorney as to their recommendations for bond and release conditions. So just give them one moment, okay?
Yes, ma'am.
You're welcome. I'm sorry. I don't have page numbers. Does anyone know what page number Mitchell is for the docket? I'm sorry? 18. Thank you.
Your Honor, I'm going to be requesting.
Hold on a second.
Sorry, sir.
Mr. Linder?
Thank you, Your Honor. I'm going to be requesting a $7,500 bond on 1, $5,000 bond on count 2, no victim contact. Mr. Mitchell was released from state prison in late 2018. That was after being sentenced to 6 years in state prison after a violation of probation on a 2013 robbery with a firearm, deadly weapon, possession of a firearm, ammunition by an adjudicated delinquent. My concern obviously being previous crime of violence involving a firearm when he wasn't even supposed to be in possession of a firearm. And now we find ourselves here today again, him charged with another offense and unlawfully being in possession of a firearm.
I think that's going to be more than Mr. Mitchell's family and his girlfriend can afford. I am going to call his girlfriend after court to see what she can do about raising bond, but I think that what the state is asking for is going to be excessive for the family. He does live with his dad, and as the state has pointed out, this is not his first contact with the criminal justice system. He does have a very close relationship with his mother, and hopefully the family can come up with something. I'm going to ask for a $1,500 bond on count 1 and a $1,000 bond on count 2, and I think that might be in the range that the family can make.
Please.
Mr. Mitchell, was there something that you wanted to say?
Yes, ma'am. I know this is not trial.
Okay, hold on one second. I'm just going to caution you and just tell you, I do not want you to say anything about the facts of the case, because understand what I said at the beginning today. You are being recorded, and anything you say can be used against you later. So I'm only addressing bond and release conditions today. Do you understand that?
Yes, ma'am.
Okay. Do you still want to say something?
I just want to say nothing got found from me, ma'am. That's it.
Okay. set bond on count 1. That will be set at $2,500. Bond on count 2 will be set at $1,000. There will also be a no victim contact order. Mr. Mitchell, I don't know if you know the alleged victim in this case or not, but whether you do or not, I just need to advise you that no victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party media, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
Okay. All right. Thank you very much.
All right, thank you, ma'am.
You're welcome. Adam Malik. Good morning, Mr. Malik.
He's here, present, Judge.
Thank you. Mr. Malik, you're before the court this morning on 3 charges. Count 1, possession of heroin. Counts 2 and 3 are each felony probation violations. Those have no bond holds. I find probable cause. I do see that Mr. Malik has a hearing before its division judge tomorrow morning. In light of that, is there anything that the parties want to add for count 1?
No, Judge.
All right, then that bond will remain in place. Thank you. Lil Clifford Sutton.
Mr. Sutton's here at main, Judge, approaching. Come on up, Mr. Sutton.
Thank you. Good morning, Mr. Sutton.
Yes, ma'am. Good morning.
Mr. Sutton, you're before the court this morning on 3 charges. Count 1, burglary of a dwelling structure or conveyance armed. Count 2, possession of weapon or ammunition by convicted felon. Count 3 is also for possession of weapon or ammunition by convicted felon. I find probable cause, and I will hear from the parties.
Mr. Romero wants to proceed, that's fine. I'm not seeking a no bond.
Judge, my understanding in count 1, according to my docket, is the armed portion of it an error.
I don't
I'm
believe.
I'm not seeking no bond.
Okay, it's not an error based on the probable cause affidavit, I can tell you that, but what Mr. Linder has told me is that the state's not going to seek no bond on it. So if you want to proceed with your recommendations, then I'll hear those now.
Judge, what I wanted to ask, I believe there's a co-defendant. I wanted to, Mr. Mitchell, what was Mr. Mitchell's bond on his case?
I don't have it in front of me anymore.
It was the last case.
He had different charges though also. He was the co-defendant was the alleged driver.
Judge, it's me, Mr. Sutton, though. He's 27 years old, been here his whole life. Right now, he's unemployed. He's looking for work. He lives with his grandmother. My understanding, Judge, and speaking Mr. Sutton, she really has no sort of kind of financial means to post much of a monetary bond. So Mr. Sutton's not going to be able to afford very much. So I'm asking you at this time to take that into account, determining reasonable release conditions for Mr. Sutton.
Do you have no recommendations?
Judge, right now, my understanding is he's going to be a father soon. Right now, he was trying to find work in order to help his fiance out, but from what he advised me, he's not going to be able to afford much. His family's not going to be able to afford much. At most, we're asking for Basically a $2,000 bond on count one, and a $1,000 bond on count two, $1,000 bond on count three.
Here that Mr. Sutton and his co-defendant are in different situations as far as their history. I'm just trying to obtain one detail before I proceed. Mr. Sutton was released from state prison August of 2018, and that was for essentially the same offense he's before the court on. It was a 2016 burglary of a conveyance and a theft. He was sentenced to 36.5 months state prison as a habitual offender. Prior to that, he had a 2012 strong-arm robbery where he was sentenced to 30 months in Florida state prison, and a resisting with violence and unlawful use of false name ID in 2012 with a VOP for 30 months state prison. So it would appear that pretty much consistently from 2012 till August of 2018, Mr. Sutton has been in state prison. As Your Honor noted, it would appear based on the allegations that Mr. Sutton is the one that actually broke into the vehicle. I'm going to be requesting again a $7,500 bond on count one, $5,000 bond on count two for the firearm, $1,000 bond on count three for the ammunition. No victim contact.
All right, on count one, bond will be set at $5,000. On count two, bond will be set at $2,500. On count three, bond will be set at $1,000. There will also be an order of no victim contact. Mr. Sutton, I don't know if you know the alleged victim in this case or not, but whether you do or not, so that you understand, no victim contact, in addition to not being in the same place at the same time, means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
All right, thank you. John Schultz.
Mr. Schultz, come on up.
Good morning, Mr. Schultz.
Good morning.
Mr. Schultz, you're before the court on count one, possession of weapon or ammunition by convicted felon. Count two, possession with intent to sell, manufacture, deliver heroin. Count three, possession of cocaine. Count four, tampering with or fabricating physical evidence. Count five, improper exhibit of a firearm or dangerous weapon. I find probable cause for these charges, and I will hear from the parties. Mr. Romero, you can proceed if you want.
Judge, he's 27 years old, been here his whole entire life. He is working. He's been working for a car detailing company for the past 4 months. He gets paid about $80 a day. He lives in Pompano Beach with his family, Judge. He specifically lives with his parents. They're both, from what he advised me, his grandparents. They're both elderly, over 85, and my understanding is Mr. Schultz basically helps them. They rely on him in every day as far as medication, doctor, everything you could think of, Judge. My understanding, Judge, he had contact with the criminal justice system, but I believe it's been several years, about 8 years, from what he advised me, he's been clean. We're going to ask the court to sign a phone order so he can get in contact with his friends and family and help post his bonds. He doesn't think his grandparents can afford very much. He has a friend that works with him in the same company as far as car detailing that he's also going to be relying on. Judge, we're going to be requesting a $1,500 bond on count one on his behalf.
Your Honor, I'm requesting a $5,000 bond on count one, noting according to the probable cause affidavit that, oh wait, one moment, Your Honor, if I could have it, sorry. how much were you requesting? I'm fine with that.
All right, in light of that, bond will be set on count 1 at $1,500. Standard bonds will remain in place on counts 2 through 5.
Judge, and I don't know if I said this, a phone order. One
Yes,
more question.
I'll sign the
Okay.
phone order. Thank you. Taekwon Cheatham. Good morning, Mr. Cheatham. Mr. Cheatham is before the court on count 1, grand theft auto. Count 2, resisting an officer, obstructing without violence. Count 3, fleeing with disregard of safety to persons or property. Count 4, operating without a valid driver's license. Count 5, leaving an accident unattended or leaving vehicle or property without leaving identification. Count 6 and 7 are each a separate count for disobeying a stop sign. Count 8 is failure to use due care. Count 9 is careless driving. Counts 6 through 9 are traffic citations that are not for magistrate. I find probable cause for these charges, and I will hear from the parties.
Requesting a $10,000 bond on count 3. The court should be aware, and I believe Mr. Cheatham poses a danger to the community and should be considered a flight risk. Mr. Cheatham is out on bond right now for fleeing and eluding law enforcement and grand theft auto. He posted a total bond of $2,000 mid-November of last year. It is obviously up to the court whether you choose to sua sponte revoke his bond or not. I am concerned that he is before the court today for the identical charges that he was out on, that he's already out on. Also noting the driving pattern in this case, that he cut in and out of traffic, failing to stop at multiple stop signs in a residential area. He was driving in the opposite flow of traffic on Sterling Road while other vehicles were present. And ultimately, this only stopped because he collided with another vehicle. And even then, he attempted to flee the traffic crash scene on foot.
What's the case number in the other case?
19-13553 CF10A.
Based on the fact that the other case, it appears that he posted his bond in November, which was only a couple of months ago, and these are the same or similar charges. This time, the court is going to sua sponte revoke Mr. Cheatham's bond in case number 1913553 CF10A. I will sign an order on that, and at this time, I'll hear the parties' recommendations.
Judge, I understand that he was out on a case. My understanding is that his mother posted his monetary bond on that case that he was out on. I see that he's picked up similar offenses, specifically on count 3. I was going to be requesting the court impose a $2,000 bond. What I was going to be asking the court, rather than hold him no bond on the case that he's currently out on, which is the most severe sanction that the court can impose, I'd ask the court to consider setting a monetary bond on that, and plus pretrial release, and with the added condition as far as no driving. I believe with those two things in place with supervision, that should hopefully alleviate the court's concerns. Right now, Mr. Cheatham, he just went through a job interview. He got hired, and he was actually supposed to start job training today at Burger King. He's 18 years old. He's been living in our community since he was 1 year old. He lives in Dania Beach with his mom. His mom works as a reservation agent for a cruise line. My understanding, speaking to Mr. Cheatham, his mom is supporting his 6 other siblings. So financially, they're not going to be able to afford to post much. That is why I was going to be requesting a combination of a bond plus supervision on Mr. Cheatham's behalf, Judge.
Your Honor, I would be recommending, as far as the revocation, that it be no bond. I don't believe Mr. Romero has really presented any argument that should give the court confidence that Mr. Cheatham will comply with the court's conditions. An order of no driving, I don't see what that would do. Mr. Cheatham admitted that he fled from law enforcement because he doesn't have a driver's license. He knows he doesn't have a driver's license. That doesn't seem to stop him from getting involved in these incidents. The GPS monitor, well, he knew from his last arrest that if he committed a new law offense, he could be facing no bond. Letting him out and saying, well, you face the same consequence again, I don't see why the court should have confidence that we can avoid similar behavior. I would ask that it be kept in no bond, and the defense can obviously seek, if the court chooses to do that, the court could seek a modification, the defense could seek a modification before Judge Fine.
Right, based on the circumstances that have been presented, in the case that I've revoked his bond, I'm going to hold him no bond at this time. That matter can be further addressed before his division judge. On the case that is pending before the court today, bond on count 3 will be set at $7,500, and the other standard bonds will remain in place at this time. All right, and I have
Yes, our Spanish interpreter is present, Judge.
You do the order for me. Revoking this bond? Or is pretrial going to do that? Are you pretrial? Does pretrial do the order for me on that other case? Or is... It will prepare it. Thank you. All right, so let me go over to our cases that require a Spanish interpreter. First up will be Jamie Gallon Hernandez on page 13. And
He's approaching, Judge.
thank
He's
you.
at me.
And for my interpreter, do you swear or affirm to interpret from Spanish to English and English to Spanish to the best of your ability?
I do, Your Honor. For the record, Igor Felicione, Spanish interpreter. Good morning, Your Honor.
Thank you. Good morning. Good morning, Mr. Gallon Hernandez.
Buenos días, señor Galán Hernández.
Buenos días.
Good morning.
You are before the court this morning on one count of DUI, alcohol or drugs, first offense.
Usted está frente a la corte la mañana del día de hoy por un cargo de manejar bajo los efectos, alcohol o drogas y es su primer ofensa.
I find probable cause,
Hallo que hay causa probable.
and I will hear from the parties as to bond.
Ahora voy a escuchar a cada una de las partes con respecto a su fianza.
Judge, at this time, nothing to add from the defense. I'm going to be contacting his wife to post his bond.
En este momento la defensa no tiene nada que agregar, su señoría. Vamos a estar contactando a la esposa del señor para la fianza. La fiscalía no tiene nada que agregar.
In light of that, the $500 standard bond will remain in place.
A la luz de eso, la fianza de $500 que es estándar permanecerá en vigencia.
Next will be Jason Baca Soto on page 16.
He's approaching, Judge. He's here, me. Senor Baca Soto.
Good morning, Mr. Baca Soto.
Buenos días, señor Bacasoto.
You're before the court on count 1, possession of cocaine.
Usted está aquí frente a la corte la mañana del día de hoy por el cargo número 1 de posesión de cocaína.
Count 2 is a learner's driver's license violation.
El cargo número 2 es una violación de una licencia de aprendizaje de conducir.
Count 2 is not for magistrate.
El cargo número 2 no es para esta corte de magistrado.
I find probable cause, and I'll hear from the parties as to count 1.
Hay un motivo fundado y ahora escucharé a ambas partes con respecto al monto de la fianza para el cargo número 1.
Judge, it's me, Mr. Baca. He's 19 years old. My understanding he's been here since he was about 14 years old.
Su señoría, hablando con el señor Baca, él tiene 19 años de edad. Entiendo que él ha estado aquí desde los 14 años de edad.
He attended Stranahan High School, and at this time he is working. He works as a painter.
Él fue a la secundaria Stranahan y en este momento está trabajando como un pintor.
He lives in Davie with his mother, Judge.
Vive en Davie con su madre, juez.
More importantly, Judge, I believe this is his first time he's ever been arrested in his life.
Pero lo que me parece más importante es indicar que esta es la primera vez que él ha sido arrestado en toda su vida.
Just considering this a non-violent offense, I'm going to ask the court to consider releasing Mr. Baca Soto straight ROR.
Considerando que esto no es un delito violento, puedo solicitarle a la corte que considere liberar al señor Baca bajo su propia responsabilidad.
If the court's not comfortable, then I'm going to be contacting his family to post his monetary bond, Judge.
Si la corte no se encuentra cómoda con esta solicitud, voy a estar contactando a la familia del señor para que pague su fianza.
resides in Davie,
Héctor, él vive en Davie.
Yes.
showing Fort Lauderdale address.
Aquí tengo una dirección de Fort Lauderdale.
2621 Riverland Drive.
Riverland Drive. It's 2621 Riverland Drive.
Es 2621 Riverland Drive. Sí, eso es Fort Lauderdale.
Sorry, Fort Lauderdale.
Ok, disculpe, Fort Lauderdale.
Just want to make sure for his court notice.
Sí,
I'll leave it in the court's discretion.
la fiscalía solo quería asegurarse de la dirección para que el señor pudiera recibir sus notificaciones, pero en este momento lo deja todo a la discreción de la corte.
Are you showing he has no priors?
La corte le pregunta a la fiscalía si tiene algún antecedente. La fiscalía responde que él no tiene antecedentes.
All right, I will ROR him on count 1.
Voy a liberarlo bajo su propia responsabilidad en el cargo número 1.
Mr. Baca Soto, so that you understand,
Yes, ma'am.
though you are going to be released today, that does not mean that that's the end of the case.
Señor Vaca Soto, para que usted lo entienda, a pesar de que usted está siendo liberado el día de hoy, esto no significa que su caso se terminó.
That means it will be your responsibility to keep in contact with your attorneys and the clerk's office
Será su responsabilidad permanecer en contacto con su abogado y con la oficina de secretaría de la corte
to monitor any future court dates that you need to be present for.
para monitorear cuáles fechas futuras usted tiene que estar presente en la corte.
If you fail to appear at those court dates, then that judge may issue a warrant for your arrest. Do you understand that?
Si usted no se presenta en la corte en esas fechas futuras, el juez que le toque podrá emitir una orden para su captura. ¿Entiende eso?
Sí.
Yes.
All right, thank you.
Ok, muchas gracias.
Ernesto Rodriguez. Thank you. Good morning, Mr. Rodriguez.
Good morning.
Buenos días, señor Rodríguez.
You are before the court this morning on an ad charge.
Usted está frente a la corte de la mañana del día de hoy por un cargo adicional.
This is an immigration hold.
Esto es una retención de inmigración.
I find probable cause.
Hallo que hay motivo fundado.
And Mr. Rodriguez, this has a no bond hold,
Señor Rodríguez, le informo que esto es una retención sin fianza,
which means you'll have to go before an immigration judge to further address this matter.
lo cual significa que usted tendrá que ir frente a un juez de inmigración para resolver este asunto.
Good luck to you, sir.
Le deseo buena suerte, señor.
Is there anyone else at any of the facilities, including Maine, that requires a Spanish interpreter?
Oh, no. Oh, Portuguese. Okay.
Yeah, okay. No one else needs a Spanish interpreter? Okay, thank you, Igor. Have a good one. Okay, we're still waiting on our Portuguese interpreter, so I'll let you know when they come. All right, so going back to our regular list, Xavier Wheeler.
Present Judge of Maine.
Thank you. Good morning, Mr. Wheeler.
Morning.
Mr. Wheeler, you're before the court this morning on one charge. This is throwing a missile into a dwelling, vehicle, building, or aircraft. I find probable cause. We'll hear from the parties. It does appear that Judge Shearer issued this as a non-custody habeas. Okay, I'll hear from the parties. Mr. Romero, you can proceed if you would like.
Judge, Mr. Wheeler unfortunately has very, very limited financial resources, and his mother does not have much more. We're going to be requesting a $2,000 bond on Mr. Wheeler's behalf. Now, he's been here in our community his whole entire life. He's 31. Right now, he's unemployed. He was working at a company called Extreme Recreation, where he was basically cleaning, making $9 an hour, and now he's actively looking for employment. He lives in Dania Beach locally with his mother. My understanding is the rent they do not own. His mom is a housekeeper. so financially she can't afford very much. So that is why we're asking for a $2,000 bond on count one on Mr. Wheeler's behalf.
Thank you.
Your Honor, I'm going to be requesting a $5,000 bond, pretrial release of the GPS monitor and no victim contact. The reason I'm making this request, this appears to be a pattern of behavior with Mr. Wheeler. In 2019, he was convicted of 2 counts of violating a protective injunction against a different woman where there was a domestic relationship with. Prior to that, in 2016, he had a criminal mischief conviction against the same woman where he slashed her tires. In 2018, Mr. Wheeler had put out a battery against, I have one moment. He had a battery against the same alleged victim as in this case, and he just, he violated probation and had his probation revoked, it's like April 10th of this year, after being sentenced to, it's like 180 days in county jail, credit for 36 days. He's also had 2014 possession of cocaine with intent to sell or distribute, violation of probation, 15 months state prison, resisting without violence twice in 07. Nothing further.
To set bond at $2,500. However, if Mr. Wheeler does post his monetary bond, he will be released to pretrial supervision and placed on a level 2 GPS monitor. There will be an order of no victim contact, and that will include a 500-foot stay-away order from the alleged victim in this case. Mr. Wheeler, so that you understand, that means that you are to remain 500 feet or more away from this victim. That also means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
Thank you.
Your Honor, North Broward is requesting one to be called out of turn.
Okay.
It's the third case from the end of your docket, Joshua James.
Right, Mr. James.
Anytime, Deputy.
All right, Mr. James, you're before the court this morning on one charge. This is for possession of weapon or ammunition by a convicted Florida felon. I find probable cause, and Mr. James, so that you understand, I have Mr. Reedy, who is your attorney from the Public Defender's Office, here in the courtroom with me, and I'm going to now hear recommendations from both Mr. Reedy and from the State Attorney's Office as to bond and release conditions.
Yes, ma'am.
While Mr. Linder is looking things up, Judge, I would be asking the court to consider pretrial release for Mr. James. He's been a resident of Florida for well over 20 years. He's been living in the same location for 20 years. And he lives with his grandmother, who unfortunately does not have a lot of financial ability to post a monetary bond. He's been working construction for the last 15 years. I know that he has had contact with the criminal justice system before, but he does have strong ties to the community, and I would be asking the court to consider pretrial release.
Your Honor, first, I don't believe Mr. James is a good candidate for pretrial. I'm concerned about his criminal history, and even more so about his very recent criminal history and just the connections to this case. Your Honor, he has a pending theft, and the theft is it's alleged December 6th of last year, he went into a Walmart and stole several items, including several large knives. Now he's before the court for trying to steal at a Walgreens while he was in possession of a large knife. His history includes 2011, 2 counts of aggravated battery against a law enforcement officer, aggravated fleeing and eluding, resisting with violence, just under 66 and a half months in Florida State Prison as a habitual offender, resisting with violence.
Hold on one moment, Mr. James.
Resisting with violence in 2008 with the VOP, 30-month state prison. Theft 07, dealing with stolen property, 2 counts in 06 with the VOP. Your Honor, considering this is the second incident in just over a month where he's in a store, there's allegations of theft or attempts to commit a theft, revolving around being in possession of knives, I'm requesting a $2,500 bond.
Your Honor, can I say something?
As long as it's-
Hold
as
on
it's
just one
not
second,
about-
sir.
Yeah, so, Mr. James, your attorney, Mr. Reedy's here to make argument for you. I just want you to understand that the reason that he cautioned you in speaking is because everything that we say today is being recorded and can be used against you later, okay? So today I'm just hearing about bond and release conditions. Do you understand that?
Yes, ma'am.
Okay.
Judge, I understand the charge involves a knife. I don't believe the knife was actually involved in the actual crime itself. I don't believe it was brandished in any way, so it's really possession. I understand the state's concern, but quite frankly, this gentleman's not going to be able to post bond, Judge, of a monetary nature or very low monetary bond at best. So again, I'd be asking the court to consider pretrial release.
State, does he have any failures to appear in his history?
Check, Your Honor, but while I'm checking, whether it was brandished or not, he's not supposed to be in possession of one to begin with.
Don't have it yet, I don't think.
And that's the inherent danger, that he's committing a theft where if a loss prevention officer catches him and wants to try to stop him, he's the one in possession of a large knife. I'm checking, Your Honor. I mean, I can tell you as far as Broward, based on his history, it doesn't appear he had opportunities to be out. I mean, he was kept in custody on the aggravated battery on an officer because at the time of that arrest, he was in violation of his probation on the resisting with violence that he ended up getting 30 months in state prison on. And that goes back to 2008. He was... I'm sorry, he was given... Here's what happened, Your Honor. When he was arrested on December 6th, he was given pretrial. When it was downfiled to a misdemeanor, I don't know if pretrial ever went to his misdemeanor judge to see if he wanted to stay on, but he was already let out without having to post a bond. And now he's back before the court, again, with the offense involving weapons.
Is he on pretrial now?
No, what happened was, well, technically no, because what happened was he was on pretrial in the felony case. My understanding is what pretrials does or is supposed to do is if a case gets downfiled, they go to the county court judge, hey, do you still want him on pretrial? And now it's your case. I don't know that that was ever done in this matter. But regardless, I mean, whether he's on pretrial or bond, there's obviously always, or even just a straight ROR, there's always, you know, the pretrial release condition, no new law offenses.
At this time, I'm going to impose a $1,500 bond. And this should go without saying based on the circumstances, but I'm also going to enter an order that Mr. James possess no weapons, firearms, or ammunition. Mr. James, that means that if you are in possession of any of these items, then you are to surrender them to local law enforcement. Do you understand that?
Yes, ma'am.
All right, thank you.
Can I just say one more thing?
As long as it's not about the facts of the case.
No, it's not. It's just they're saying that I was allegedly shoplifting. I didn't get caught with any stolen merchandise or anything on me.
I understand, sir. That charge, there's not a charge for that pending. I understand.
So, okay.
Okay, all right. Okay, thank you, Mr. James. Okay. Kimani Brown.
Chairman.
Thank you. Good morning, Mr. Brown.
Good morning, Miss.
Mr. Brown, you're before the court this morning on charges 1, 2, and 3 are felony violations of probation. Those each have no bond holds. Count 4 is a misdemeanor capias. That was a charge for resisting or obstructing without violence. I find probable cause. And Mr. Brown, I see that you're going to be going before your division judge tomorrow morning to address the no bond holds. In light of that, he also has a hearing the next day on the misdemeanor case in front of his division judge. So I'm going to leave that in place. John Brown.
He's approaching, Judge.
Thank you. Good morning, Mr. Brown.
Good morning.
Mr. Brown, you're before the court this morning on 2 charges. 1 is for driving while license is suspended, third or subsequent offense. Count 2 is an out-of-county felony hold that is out of Bay County that has a no bond hold on it. I find probable cause. In light of that, do the parties wish to be heard on count 1?
Yes, Judge, I'm just requesting a phone order.
Okay. All right. I will sign that order. And the standard bond will remain in place at this time. Thank you. Joshua Santamoro.
I've been informed medical reset.
All right. Thank you. Joseph Stafford.
No problem.
Thank you. All right. Good morning, Mr. Stafford.
Good morning.
Mr. Stafford, you are before the court on count 1 is for grand theft auto. Count 2 is second-degree petty theft, first offense. I find probable cause, and I will hear from the parties.
State at this time, Your Honor.
Okay, Mr. Reedy, do you wish to be heard?
Judge, I'm going to ask you to consider pretrial release. Mr. Stafford has lived here all of his life. He has given me the number of his sister, and I intend to call her or try and get a hold of her. But I think what has happened here, actually, from what he tells me, and he is looking forward to his day in court, is that it was his sister's car that was taken. He was not aware that she had reported it stolen. Nobody was able to get a hold of her all day, and eventually he got stopped and arrested. But I think when this thing all settles out, there's going to be probably either no charges filed or something will happen with the case to resolve it. Until that time, though, unfortunately, he does not have the ability to post a monetary bond. So I would ask the court to consider pretrial release.
I don't know, I can't know what Mr. Stafford's advised Mr. Reedy, but my reading of the facts are just completely the opposite of what he just stated. Post Miranda, Mr. Stafford admitted to breaking into his sister's home while she wasn't present, while she was out of town, to steal her car. And law enforcement spoke to her, took a sworn tape statement from her, and she said she does wish to pursue legal remedy with regards to her stolen vehicle. And also, Mr. Stafford admitted going to several unlocked cars and a mailbox at unknown locations. The only reason he hasn't been charged with those is because they couldn't locate victims at this time. He stated he took 2 credit cards, which were found inside of his wallet. Your Honor, considering these allegations and that I'm seeing the booking sheet shows an at-large address, I'm asking that the bond be kept in place. I don't see a history, but I don't know why he's indicating that there's some legitimate reason for what he did.
Mr. Reedy, is the sister that you're referring to, the sister referenced in the probable cause affidavit, Jessica Stafford?
Yes, Judge.
Oh, and also, Your Honor, we're going to be asking for a no victim contact, so you won't be able to reach out to her.
Well, that's what I'm asking.
Okay, we have no problem with a no contact order regarding Mr. Stafford's sister. You know, and again, you know, we're hearing kind of one side of the story is not uncommon in magistrate court. I feel that, you know, once things get unraveled, we'll see what did happen. And I would like to see Mr. Stafford not remain in custody while that determination is being made.
Okay. Well, the while I understand what you're saying, Mr. Reedy, based on the allegations in the probable cause affidavit, it paints a different story. So obviously, this court has no way of knowing, whether the version of events is any different from the probable cause affidavit, since those facts are not before me today. So at this time, I am going to leave the standard bond in place. There will be an order of no victim contact. If the situation changes later, then that will be for another judge to decide. But for today's purposes, Mr. Stafford, so that you understand, no victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
All right. Thank you very much.
All right, good luck, Mr. Stafford.
Thank you.
Ledatrick Bullard? Yes? Dade? Just the numbers, you don't have any letters or anything? Okay. Okay. All right, good morning, Mr. Bullard.
Good morning, Judge.
Mr. Bullard, you're before the court this morning on charge 1 is for unlawful speed. That is not for magistrate. Count 2 is a felony probation violation. That is out of Dade County. Counts 3 and 4 are felony capiases. Those each have no bond holds on them and are not for magistrate. I find probable cause. And you will be going before your division judge tomorrow morning to address that matter. Thank you. Rafael Pabon? Yes,
He's approaching, Judge.
thank you. Okay. Okay. That's what I was going to ask you about anyway. All right. Good morning, Mr. Pavone.
Good morning, Judge.
Mr. Pavone, you are before the court this morning on a total of 5 charges. 1, burglary of an unoccupied dwelling unarmed. 2, larceny, $300 less than $10,000 from a person 65 years of age or older. Count 3, unlawful possession of personal identification of another. Count 4, resisting an officer, obstructing without violence. Count 5, trespassing on property, not a structure or conveyance. I find probable cause, and I will hear from the parties.
Judge, right now, Mr. Pavone is not working. He was working at Dunkin' Donuts. He's no longer working there. He lives in Pompano Beach with his sister. My understanding, the only person that's going to be able to help post his monetary bond is his sister. She works for a marketing company in their customer service department, making minimum wage. So he's really not going to be able to afford to post any sort of bond. But we're going to be asking, Judge, on count 1, if the court would consider a $2,000 bond. We're going to be requesting on counts 3, 4, and 5 if the court would consider an ROR on those matters. And we're going to be asking the court to sign a photo order so we can photograph the injuries Mr. Pavone sustained.
Oh, Your Honor, as far as bond, I'm going to be requesting a $25,000 bond on count 1. As far as any other release conditions, that really will be depend on what actions the court chooses to take or not to take. Mr. Pavone is a clear and present danger to the community, the property in the community, to people's homes. The court should be aware Mr. Pavone is out on bond right now. He was arrested August 1st and released November 14th of last year for charges of grand theft auto, felony petty theft, and resisting without violence. One thing I think the court should be aware of, the felony petty theft, he is accused of stealing a woman's wallet and electronic equipment, namely a laptop. And it's relevant because in this case, he was found walking the vicinity from a home that was just burglarized with the victim's laptop under his arm. Now, Your Honor, the court should also be aware that in 2014, Mr. Pabon was convicted of burglary of a dwelling and grand theft and sentenced to 5-year state prison as a habitual offender. 2013, burglary of a dwelling and felon carrying concealed weapon, a little over 5.5 years state prison as a habitual offender. He was released from state prison May 6th of 2019. And I bring that up because, as I mentioned earlier, on his pending case, he was just arrested August 1st of 2019. He has additional priors for grand theft, 2 counts in 2007 and 1 count of theft. He violated probation, was sentenced to 66 months in state prison as a habitual offender. Grand theft in 2006, between $10,000 and $20,000. VOP, 60 months in state prison. 2002, 7 counts of burglary of a conveyance, just under 40 months in Florida State Prison. Theft 01, burglary of a dwelling and theft in 1995. VOP, 6-year state prison. 1995, armed burglary of a structure and 3 counts of grand theft. VOP, 6 years state prison. So essentially what Mr. Pabon has shown from 1995 until right up to now, there's really not been, from what I can tell, any serious period of time where he has not been in state prison for committing burglaries in Broward County. Your Honor, it's up to the court whether you choose to sua sponte, revoke his bond on his pending case, but he has shown that Your Honor and no judge really should have any confidence that Mr. Pabon will not commit criminal acts if he's out of custody. $1,750, Judge. But the court should also be aware, when he was arrested, he had a parole hold. So the court might have taken into consideration that he had a no bond hold. Those parole holds were ultimately dismissed, and then he posted the $1,750 bond in November.
What's the case number in that case?
199602 CF10A.
Romero?
And Judge, my understanding is Mr. Pabon did advise me as far as that case that he was out on. I believe his family used the services of a bondsman, and I believe the premium was about $200. But right now, Judge, he really and his family doesn't have anything else. Now, my understanding is he's gone to court on that. He's applied for, he has a public defender on that case. Judge, I'm asking you not to take any action on that case. And I know I initially just requested a $2,000 bond. I wouldn't object because of the totality of the circumstances. The court also wanted to impose Mr. Pabon with pretrial release.
Based on his history, I'm very concerned, especially because the charges are the same or similar to many of the charges that are in his history. In this case, we're dealing with a residential burglary here, and taking into consideration the fact that the alleged victim is over the age of 65 years old, it gives me great concern. This isn't a case like many of the ones where we see defendants that are pulling on car door handles. We're dealing with someone's home here, and that obviously makes things much more serious. Based on the circumstances and everything that's going on here, at this time, the court is going to sua sponte revoke his bond in case number 199602 CF10A, and I'm going to order that he be held no bond in that case. On this case, on count 1, bond will be set at $10,000, and the other standard bonds will remain in place. There will also be an order of no victim contact. Mr. Pabon, I don't know if you know the alleged victim in this case or not, but whether you do or not, no victim contact, in addition to not being in the same place at the same time, means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
Thank you. Juan Gaviria.
Line up, sir. He's approaching, Judge.
Thank you.
Nothing.
Mr. Gaviria?
Good morning, Judge.
Mr. Gaviria, you are before the court on a total of 9 charges. Count 1, driving while license is suspended or revoked. Counts 2 and 3 are each felony capiases, which have no bond holds. Counts 4, 5, 6, and 7 are juvenile court orders. Those have no bond on them. Count 8 is for trespassing on property while armed. Count 9 is for grand theft auto. I find probable cause. Do the parties wish to be heard? Mr. Romero?
Nothing to add, Judge Hogan.
All right, Mr. Gaviria will be seeing his division judge tomorrow. James Monroe? Thank you.
This
Okay.
is a
This is a
perfection, Your Honor.
perfection? Yes, come on up. All right. Good morning, Mr. Monroe.
Good morning.
All right, so this is a perfection. The first appearance was held over the weekend before Judge Barner. All right.
That he had been previously trespassed on prior to the arrest.
Right, so just for the record today, this is a perfection as to charges 1 and 2. That's resisting an officer obstructing without violence. 2 is for trespassing of an unoccupied structure or conveyance. Based on the probable cause affidavit, I do find probable cause for these charges, and I will hear from the parties.
Your Honor, in light of the violation of probation, I'm not making any request.
As in having reviewed the amended probable cause affidavit, we have nothing further to add, Judge. I don't know what the attraction is to Wawa, but apparently it's 100 or so students or juveniles at this place.
Yes.
So I don't know what's going on with that, but Mr. Monroe, you need to stay away from that place. But other than that, I've got nothing else to add, Judge. He's got a no bond hold.
Okay, in light of the no bond hold, then I'm gonna leave the $100 bond in place on count 1. And Mr. Monroe should be going before his division judge shortly to address the no bond hold. Good luck to you. Good luck, Mr. Monroe.
Thank you.
Okay, Cameron Hobdy. Thank you.
Medical reset.
Well, we have to address it, Your Honor. It's a perfection.
Okay, tell me what's going on.
My understanding was that Judge Barner did not find probable cause for burglary of a structure, and I spoke to the ASAs that were here yesterday, and my understanding was, and now upon further reading it, this should be, there should be PC for an attempted burglary, Your Honor. I don't know that it was raised. I just know that my understanding, what I was told, is that Judge Barner did not find probable cause for burglary, which I would agree. It's clearly not a burglary, but I would note, based on the, and as the court is aware, the deputies are not able, since there is no one statute for attempted burglary, they can't book him for attempted burglary. But I would note just the, based on what the deputy saw and the statement that was given by Mr. Hobdy, that there is probable cause for attempted burglary.
I don't disagree with that.
Okay. Then I do see, I'm looking at the probable cause affidavit. I do see that. So what I'm going to do is I will find probable cause for the attempted burglary. I'm going to write attempted in here. And I guess we'll have him reset just as to bond.
Yeah, Your Honor, and really, it's up to Mr. Reedy, whatever he wants to do. Considering that Mr. Hobdy's already been in since the 25th, and frankly, there should have been a PC finding for attempted burglary at the other time. If Mr. Reedy wants Your Honor to set some type of bond, and if he can post it, great. If not, have him reset for tomorrow so Mr. Reedy can get some information from it. And
Oh, we could do both.
That's what I'm saying.
Yeah.
That's what I'm saying. I'm fine with that.
Yeah, I
All right.
assume he'll be coming on the second look docket anyway.
I'd ask for a $1,000 bond.
It's set at 100 right now. I'm not sure, yeah, it's set at 100 on the burglary. I'm not sure if the attempted burglary, if that makes a difference.
I think it was set before the judge.
Oh, I see,
Because
she
no
said
PC
it.
determination had been made.
Yeah,
Okay, well, then I would argue, Your Honor, I mean, it is an attempt, but based on the statements, it's clearly more than a trespass, since he admitted he was in the area to steal a car and failed. Brian, you asked for 1,000? I'm fine with that.
Right, then bond will be set at $1,000. And if he doesn't post the bond, then I'm sure we'll be seeing him on the second look docket. Okay. Thank you. All right, so the only cases that I have remaining are the ones requiring a Portuguese interpreter. So what I will do is, and Mr. Romero, the only remaining cases that you have at Maine are just the 2 Portuguese interpreter cases, correct? All right. We do, which facilities, yeah? Yes. I don't have it. Okay, what we're gonna do, I'm being told we may have a third case, but the paperwork is somewhere in the courtroom. So while I'm waiting on the interpreter and locating that paperwork, I'm just gonna take a very brief recess and we'll come back in a few minutes when I have that ready to go.
And the Portuguese interpreter, I'm told, is between 2 different courtrooms over in the other building and should be on her way soon, so.
Okay. We'll wait a few minutes. It's 11:30 now. We'll give her a few minutes since we're quickly approaching the afternoon docket. We'll come back in a few minutes and reassess what we need to do, okay?
Very good, Judge.
All right, we'll be right back. Okay, we're back on, so we have only 2 cases left, and we have our Portuguese interpreter present.
Ok, agora temos 2 casos e temos a intérprete para o português presente.
And for my interpreter, will you please raise your right hand? Do you swear or affirm to interpret from Portuguese to English and English to Portuguese to the best of your ability?
I do that. Afirmavas de faria, movia, yes.
Thank you very much.
Thank you.
Okay, and we have Lima Sormani.
Temos
This is Mr. Luis Santos.
Okay, I'll
Ok,
take that.
temos o senhor Luiz Santos, excelentíssimo.
Okay, good morning, Mr. Santos.
Bom dia, senhor Santos.
Bom dia.
Good morning.
You are before the court on 2 charges.
Ok, o senhor está perante a corte devido a 2 acusações.
One is possession of cocaine.
Uma é posse de cocaína.
2 is trespassing on property not a structure or conveyance.
Ok, a outra é invadir uma propriedade que não é uma construção.
I find probable cause.
Eu julgo haver causa justa e provável.
And I will hear from the parties.
E agora eu vou escutar as partes.
Judge, nothing to add. I'm going to contact Mr. Santos' friend to post his monetary bond.
Ok, excelentíssima, não tenho nada a acrescentar. Vou falar com a amiga do senhor Santos para pagar a fiança. Nada.
Then the 1,000 bond will remain in place on count 1.
Ok, tudo bem. Então, a fiança de $1.000 vai continuar em vigor para o fato 1.
Thank you.
Obrigada.
Lima Sormani.
Please approach the judge.
Thank you.
Or is another Portuguese?
This is another.
Oh, 2 Portuguese. Oh, so sorry.
You're all right. Good morning, Mr. Sormani.
Bom dia, senhor Sarmani.
Good morning.
Good morning.
Mr. Sormani, you are before the court on 1 charge for trespassing on property not a structure or conveyance.
Ok, então, senhor Sarmani, o senhor está aqui perante a corte devido a uma acusação de invasão de propriedade que não é um terreno.
Find probable cause.
Eu julgo haver causa provável e justa.
And I'll hear from the parties.
Então, agora vou escutar as partes.
Nothing to add, Judge. He's going to be posting his bond.
Nada a acrescentar, a senhora juíza, ele vai pagar a fiança.
Honor, I'm not asking for any change to the bond.
Ok, excelentíssima senhora juíza, não estou pedindo para mudar nada quanto à fiança.
I spoke to the homeowner,
Eu falei com o proprietário.
so my only request, based on my conversation with him, is an order of no return, no victim contact.
Ok, então eu conversei com ele, a única coisa que ele está pedindo, né, que estamos pedindo é que ele não volte ao local e nem tenha contato com a vítima.
Okay, the $25 bond will remain in place.
Então a fiança de $25 vai permanecer.
There will also be an order of no return.
Também vamos fazer uma ordem que não pode voltar.
Mr. Sormani, that means that you're not to return to the location this occurred at.
Então, senhor Sarmani, isso significa é que o senhor não está permitido voltar ao local onde isto ocorreu.
There will also be a no victim contact order.
Também vamos emitir uma ordem onde não pode haver contato com a vítima.
And whether you know this alleged victim or not,
Quer o senhor conheça ou não essa vítima alegada.
that means no being in the same place at the same time,
Isso significa que não pode estar no mesmo local, na mesma hora.
no phone calls,
Não pode fazer telefonemas,
no text messages,
nem mensagens de texto.
no third party contact,
Não pode fazer contato através de terceiros.
no social media.
E não pode usar a mídia social.
Do you understand that?
O senhor entende isso tudo?
Yes.
Yes.
Okay. All right. Thank you. Good luck.
Obrigada, boa sorte.
All right. That brings us to the end of our morning docket for first appearances. So I'll see everyone back here this afternoon for our afternoon docket. Thank you.
Judge, one last.
I'm here.
I'm sorry.
That's okay.
The last person who was Mr. I believe it was Mr. Santos. Can we just ask for a property order?
Yes, I will sign that order. Okay?